Today, the California Civil Rights Department announced that a federal court has ruled Grimmway Farms discriminated against disabled farm workers by forcing them onto unpaid leave.
Eyewitness News reporter Michelle Roldan breaks down the court ruling and tells us what Grimmway Farms has to say. Michelle.
That's right. The case was originally filed 4 years ago, and the California Civil Rights Department director calls the court's ruling a major victory for disability rights and for farm workers across the state. The court found Grimmway Farms forced injured workers onto unpaid leave even when other accommodations were possible. I spoke with Dolores Huerta of the Dolores Huerta Foundation, who said that during her time with the United Farm Workers Union, she saw firsthand just how common workplace injuries were.
There were so many people that would get disabled there at Grimmway, and the company would not take care of them. And not only that, but they had very unsafe working conditions. This, of course, because they did not have good, safe working conditions, a lot of people ended up getting injured.
She also told me she believes one of the reasons for these issues is that when Grimmway Farms bought out smaller carrot companies, it didn't continue the labor agreements those workers once had. In California, injured workers first receive temporary disability in about 2/3 of their average weekly pay if they can't return to work. They're also entitled to medical treatment through the workers' comp carrier, and if they're left with long-term limitations, they may qualify for permanent disability benefits.
So this applies to any worker, whether they are farm workers or not.
I spoke with Beatrice Trejo, a certified workers' compensation specialist at Chain-Con Clark. She reviewed the case and says Grimmway Farms wasn't properly following the interactive process, the system designed to help injured workers get the accommodations they need.
An example given here is that of 199 employees who were referred from the workers' compensation department to the interactive process, 197 of them were placed on leave, and then those transfer there with had accommodations of light work or modified work. So it looks like they were not really making a good faith effort in order to accommodate these injured workers back to work.
In one case from 2016, a Grimmway grader was put on interactive process leave for 8 months. By 2017, the company offered them a voluntary retirement with a payout worth less than her lost wages. I reached out to Grimmway Farms. A spokesperson said, in part, quote, "We firmly disagree with CRD's characterizations of the court's pretrial decisions, noting that many of the motions were resolved in Grimmway's favor. The allegations do not reflect principles or values that guide our company, and we will respectfully see the matter through trial and the proper legal process." As the case moves to trial, the court will decide on damages and possible relief for hundreds of farm workers. A trial date has not yet been set. In studio, Michelle Roldan, Eyewitness News.
Hi, I'm Rochelle Murcia with Eyewitness News Bakersfield Now on YouTube. Thank you for checking out our YouTube channel where we have tons of great content to choose from. While you're here, go ahead and click on the subscribe button right there. That way you can stay up to date on all the things related within Kern County. Thanks for watching.